Justice Kagan?
I mean, let me ask the same kind of question in a different way. Suppose that instead of this law, you had a law that was focused, it excluded the kind of curated news feeds where your argument about editorial discretion sort of leaps out. So this law didn't touch those. But it said, you know, with respect to Gmail and direct messaging and Venmo and Dropbox and Uber, with respect to all of those things, a site could not discriminate on the basis of viewpoint, just as maybe a site couldn't discriminate on the basis of race or sex or sexual orientation or what have you. So it just added viewpoint to the list. Wouldn't that be all right?
I actually don't think it would be all right, because all of those things are still in the expressive business. And I also think—
Well, do you think that, you know, suppose it didn't say viewpoint, it just said you can't discriminate on the basis of, you know, all the usual protected characteristics. Is that all right?
That would probably be all right, but it wouldn't save the whole statute from being—
Well, so this is just on this statute. You know, it's a statute about it excludes YouTube and Facebook and, you know, the Facebook news feed.
Right.
But it's just direct messaging, Venmo, all of those kinds of things. And it just said, you know, we're not going to let you exclude on the basis of race and sex, and we're also not going to let you exclude people on the basis of viewpoint.
So, I mean, the first part of that statute, I don't think my clients would even challenge. I mean, whether there's an abstract First Amendment right to have the Black Authors Table for Black History Month.
And also on the basis of viewpoint.
When you throw viewpoint into there, then I think, you know, I'd have to ask my clients whether they challenge that statute. But obviously that's not the statute we have here. And if you think about—
I guess what I'm saying is in part, it is the statute you have here. And that gives you your plainly legitimate sweep. Because all it's saying is that when you run a service where you're not speaking, unlike in Facebook feed, where your editorial discretion argument is good because the platform is engaged in speech activities. Well, when you're running Venmo, you're not engaged in speech activities. And so when a state says to you, you know what, you have to serve everybody, irrespective of whether you like their political opinions or not, then it seems you have a much less good argument. But this statute also says that, doesn't it?
Not really, Justice Kagan, and I think we're in danger of losing sight of the actual statute. So let me take you to Petition Appendix 97A and the definition of censor used in the statute. It says censor includes any action taken by a social media platform to delete, regulate, restrict, edit, alter, inhibit the publication or republication of, suspend a right to post, remove or post an addendum to any content or material posted by a user. The term also includes actions to inhibit the ability of the user to be viewable or to interact with another user of the social media platform. Censor is all about the expressive activity. Post-prioritization is all about, it specifically talks about a news feed, a view, search results, and they give essentially political candidates in journalistic enterprises a right to sort of non-discrimination. So they're going to pop up there, even though, like, I have no interest in politics. I just want to look at, you know, feeds about Italian bicycles. And I'm still going to get these Florida politicians popping in there. That's what this statute does. And then you go through shadow ban. Shadow ban's not about any of the things you're talking about. Shadow ban is all about content. And then we go to journalistic enterprises. They get pride of place. Then we talk about post-prioritization. That's all about how you display the content. So, like, maybe the 30-day provision, you could sort of say that, well, that applies to, like, Uber. But even then, if Uber wants to change its comment policies because all of a sudden, you know, they did one thing to try to, you know, deal with one set of issues, and then a problem comes up and there's a whole bunch of, like, people using the comments in a really rude way, like, why couldn't they change their editorial policy on the comments? I just don't understand it. And then all of the duty to explain provisions, the duty to explain provisions are all driven by decisions to exclude content. And that happens 1 billion times a quarter at YouTube. So that's a crushing blow. It has nothing to do with some of the other things you're talking about.
Thank you.